Serious, solicitors/lawyers, what's the worst case of you should have mentioned this sooner you've experienced? Spent several hours zealously arguing that my client was severely disabled and couldn't work due to a back injury. It was so bad that the poor dude couldn't even sit in a chair throughout the entire proceedings. Rest my case. Opposing counsel calls in a DEC representative who proceeds to produce record after record of my client's deer hunting activities. He sat in a tree, in freezing weather, for many hours, shot and killed multiple deer, and transported their carcasses out of the woods all on his own. SMH. What an idiot, all he had to do was lay low. My buddy used a woman's own Facebook posts and had a doctor take the stand to explain why someone with a debilitating back injury wouldn't be able to run half marathons, Tough Mudders, and do CrossFit regularly. She lost her car accident lawsuit. In-house attorney here, but I interned for a judge at our Court of Common Pleas during law school. There was a case of a guy that asked two early 20 girls a ride from the mall to a gas station. He told them he would pay them cash for the trip. During that trip, he sat in the back seat and had advised that he had a pellet gun that closely resembled a handgun. He said he had only pulled it out to show the girls but never did anything further. That had been his testimony during all the proceedings. He willingly takes the stand and the prosecutor is questioning him about the gun and how he handled it. This dude willingly admits that he held it to the passenger's temple, threatening to shoot her with what she believed to be a real gun. He also corrected the prosecutor during questioning, telling him that he never stated it wasn't a real handgun. That jury verdict came about as fast as one could. Sometimes I wonder about my own level of intelligence. Am I as smart as I think I am? And I don't consider myself to be particularly smart. Then I read something like this, say a little thanks, and have a generally good day. That's a fucking terrifying scenario for the girls. I'm glad he idioted himself into more jail time. Special ed case. School district was supposed to be providing services to the child in the home. Clients told us the school district had never sent anyone to provide the services, they hadn't heard from anyone in the district about scheduling, etc. Brought this up during a pre-hearing conference with judge and opposing counsel. After the conference, opposing counsel sends me pages of affidavits and documentation of all the times the school district employees went to the house and were refused entry by my clients for various reasons, or clients just didn't answer the door when they were clearly home. Clients had no explanation about why they lied to me. They fired us shortly after and I was not sad. Did they think the paperwork wouldn't come out? Or the fact that they're sending the help away? It's like people think lying to the attorney is going to help them somehow. The guy above me deleted. Long story short, a guy lied about stealing cars to his attorney. Attorney finds out in courtroom right before trial. I'm sure he can't leave it up due to attorney-client privilege, but my summary is scuffed enough no one will know who it is. I had a client charged with shooting and paralyzing victim. He was ID'd by a woman in the house that knew him, but the witness was potentially biased. Client says he wants to fight the case. We then discuss whether it should proceed time waived or time not waived. The difference is how quickly the case is set for trial. Time not waived means the trial is set within 60 days. Time waived means the trial can start in more than 60 days. The importance was that my client told me he was not at the scene. I stressed the importance of being honest and that everything is confidential. He again said he was not at the scene. I told him we could get cell phone records to confirm that his phone was not at the scene of the crime at the time of the shooting. And if we could show that it was active, meaning he was using it, it could help cement his alibi. I also said, but if you were at the scene, we should set this time not waived so the DA can get your cell phone records. Client says to set it time waived and get the records. So, several months and a lot of work later, the cell phone records literally show him at the fucking crime scene at the time of the shooting. It also leads to more evidence more directly linking him to the shooting. The records also managed to implicate his friend as being involved. It tuned the case from being borderline to a slam dunk for the DA. It's even more ridiculous than this, but it's kinda off topic. Edit, okay. Some more of the ridiculousness. I share the details of the cell phone data with client. He has no reaction, and offers no explanation for his prior statement that he wasn't at the scene. I explain that the DA does not yet have this information, so we should try and accept a deal now before the DA finds out, because he will most likely revoke the current offer when he does. Client insists on a jury trial. I explain that it's client's call whether we go to trial or not. I'm here to offer advice, and he's free to reject that advice. But I think it's a really bad idea because the DA will get the info before trial. When he does, the offer is going to skyrocket. Client continues to insist on a trial. My final words are, that's your call. But commit to your decision. If you reject the current offer, then try and plea later, the offer is going to go through the roof. If you want to plea, do it now. You guessed it. The jury is literally walking into the courtroom and I hear this, PSHHHHH. PSSSST. I look over and ask him what's up. He says, I know you said not to do this, but I want a deal. He bled. Because of his shenanigans his offer increased by roughly 300%. He would be out of prison if he took his original offer, and I think he has well over a decade to go currently. There's actually more, but I don't think I can share it because it's so unique that it would make it easy to identify the case. My ex-husband is like that. If you don't ask him a very specific question, he will not think to give information. How was your day? Fine. No bueno. Anything happened to your car today? Oh yeah, I got in an accident. Ah. Good lord. It's shit like this that reminds me why I never went to law school. My client was badly hurt in a car accident and promised me he was never hurt in one before. He was actually hurt in 44 prior accidents, all of which he filed claims for, which is how I found out when the mediator showed me the defense's ISO report. The fucking look on my client's face, Lamau. I guarantee if he had 44 prior accidents, he knew damn well what an ISO was. ISO is a record of your prior insured accidents. There may be some tiny insurance companies that don't report claims to ISO, but checking ISO is routine for virtually everyone. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate, in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to shit, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial, in passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as fuck, unethical, and common practice for that prosecutor office. I get the interview and all of 4 minutes in she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense I had. We had a come to Jesus talk the next day and she took her offer, which was the minimum of 5 years to serve. What would have happened if she hadn't told you? If the prosecutor had introduced the interrogation as evidence at trial without giving it to you in discovery, what happens? I'm not a lawyer, so don't know these things. I'm obviously not a lawyer, but if the prosecution is sitting on evidence and doesn't share it, isn't that grounds for a mistrial or something? Subscribe for more hot Reddit takes in your inbox, guaranteed.